Today I am going to talk on very important topic, that is that transfer of flat after the death of the flat owner. Now here very few people know that without going to the court, it is possible for us to transfer the flat to the legatees. Legatee means that those who are the successors, like a spouse. That means if husband is owning the flat, then his spouse is his wife, and children, grandchildren. Only they are the legatees, not brother or sister. If the flat is bought with his own money, okay? If the flat is bought with his own money, then these are the only legatees, that the legal rightful people. Now here, that people are of the opinion that if we a flat is jointly bought, for example, then for flat people make nominees, and earlier, that is still say March 2019, that after dying the owner of the flat, his nominee was made the owner. But now that government has made it very clear, nominee is a trustee and not a legatee. That means that because he is a nominee, the nominee cannot become the legal right holder of that flat. Somebody should remain as a trustee, so he has been issued the trusteeship. And because of this, that some legal point we have to find out. Now here, if the legatees are not having any dispute among themselves, then that flat can easily transfer to any of the legatees. How to transfer such without intervention of the court, that I am going to explain to you in today's lecture. Now let us imagine that a flat belongs to father, and he has his wife and two children, a boy and a son and a daughter. Now here, after some time, let us say at the age of 70, that flat owner expires. His wife is about 65 and his son is about 40 and daughter is about 35, and his both children are married. Now to whom that flat should go? Now if you want that the flat can easily be shared among all the people, all the legatees, that is wife and their two children. And if that is done, then that paper that is to be made is called declaration deed. I repeat, if all the legatees want the share, equal share in the property, then whatever that paper that is to be done is called declaration deed. Let us say mother is not interested in property and she want that father's flat should be shared by their son and the daughter. In that case, that one of the legatee is not interested. In that case, whatever the document to be done is called release deed. In release deed, at least one legatee is sacrificing his right in the property. And whether it is declaration deed or release deed, it is to be made on 500 rupees non-judicial stamp paper, and that stamp paper one is to buy in the name of one of the one of these legatees. In my case, there are three legatees. Buy it in any one of the name and 500 rupees non-judicial stamp paper, and then that declaration deed or release deed, as the case may be, you make it, and it is to be registered with sub-register of assurances, and that deed has to be witnessed by two witnesses. Two witnesses will put their signature for each of the legatees that they are signing the deed, whether declaration deed or release deed. And when registration takes place, even at the registration, those witnesses will also sign that in front of sub registrar of assurances. And registration fee, whether declaration deed or release deed, it is only 1000 rupees. So with only 1500, your document is done. Now some societies are telling, no, no, if you are if the person, the flat holder, has not made a will, then you get a succession certificate from the court. Now that if will is made, then on the will they will ask you get the probate of the will from the court. Now, whether probate of the will or succession certificate when will is not made, it is not necessary, it is not a compulsory, and it is a costly process. In Mumbai, Chennai, and Kolkata, that testamentary petition has to be made in testamentary division in high courts, and other places it is in the district court. And for testamentary petition it cost court fee 75,000, and even if legatees are not having any dispute among themselves, that advocate will charge not less than 50,000 his advocate's fee. So it is minimum. It goes sometimes that 1 lakh or even more. Now here, instead of doing that, why not just do a declaration deed and release deed? When you are doing the testamentary work, that means that is that probate of the will or just a hardship of the flat from the court. In that case, whatever that judgment you are getting is not a final document to transfer your flat. Remember, judgment is not a final document to transfer your flat in your name. Depending upon how many legatees are there, you will have to make either declaration deed or release deed with that judgment on 500 rupees non-judicial stamp paper and register with the sub-register of assurances. And therefore, what is the use of this testamentary petition if you are not having any dispute among yourself, and therefore that you don't do any testamentary petition, that either release deed or declaration deed, depending upon whether everybody want the is all the legatees want the part in that flat or property, you make declaration deed. If one is not interested in taking the part, then you make the release deed. Now, some people have asked me that an example I am giving, a mother was owning the flat, she expired, father alive, and they were having two children, that is, one boy and girl. Now, that boy wanted double the quantity, double the part of the mother's flat. So, how to do it? First, you do the declaration deed. Father, the mother expired, mother's that father's that mother's late mother's flat, that father, son, and daughter, everybody will get equal part. Then one third, one third, one third, everybody has got. Then once you get it, you make that father will make, after registering that declaration deed, father will make a gift deed of his one third part to the son, so that that son will get double the part of what his sister has got. So this way you can use your mind to unequally divide the property. Okay. Now, same way, once one person came to me that he was not interested, that flat belonged to his father, and he was not interested the part of it. They were three sons, and mother expired. Now that one of the son was interested in double that father's flat. Then he came to me. I told him, what to do? You do now. All of three of you declare this indeed. Everybody will get equal, and you don't want no, so you do that. Gift it to your brother so that he will get double that, or double than what other brother has got. So that way you can do some homework and get the things that properly divided. Okay, this way you can do it, and this is the way in which it is to be done, instead of fighting in the court or taking the making the testamentary petition in the court. And it is unfortunate that most of the societies in Maharashtra are not aware that without testamentary petition we can just transfer the property in the name of the legatees. Now, one flat was owned by husband and wife, and that they were having three children, one son and two daughters. Now, thing is that one of the two daughters, they were not she was not interested in that father's flat. So here, then when that mother expired in the jointly owned flat with the father, then they made a release deed of that part, so that other two, that is one son and one daughter, they got that half of the flat in their name, half half, that is 25%, 25%. So this way you can do lot of works on your own at cost saving and without going to the court. And the thing is that Maharashtra government should make this program, this some rule in the cooperative housing societies, that declaration deed and release deeds are acceptable in their cooperative societies act, so that that this can be made very easily, and without going to the court we can get the property divided easily among the legatees. Now here that I am on every Wednesday at opposite Siddhivinayak temple in one building, that Money Life Foundation is there, where I am giving free of charge guidance Wednesday evening 3 to 6 p.m. for 3 hours, and for which you'll have to make a phone call to that Money Life Foundation between 11 o'clock and 5 o'clock Monday to Friday, and take my appointment for Wednesday. Now here I am giving the number that is attached 022 to both the numbers. First number is 3513 1664, 3513 1664, and second number is 3503 6925. I repeat, 3503 6925. So here you can come and get more guidance from me, not only in this, any cooperative housing societies legal paperworks. My guidance there will be free of charge on every Wednesday. Now, here that if you are having any questions, now I am just leaving it to the people those who are seeing this, so that I can just give them, because here, if you are having any questions, you can ask me. Thank you. Over.
Good afternoon, sir.
Yeah.
Thank you very much for an enlightened discussion on this, sir. There is one clarification I wanted to check with you. Uh,
Yeah.
Suppose a property has been gifted to three people
Hmm.
in different percentages
Hmm.
by
Hmm.
somebody.
Hmm.
Now, will it be possible for those three people
Hmm.
to, for one of them to give a release deed so that some share of that person goes to other people?
No, release deed is possible only when person dies. Now here that the living person has to do the gift deed.
Acha, okay, that's what I. So
Yeah.
if any percentage changes have to be made, that percentage gift will have to be given.
Yeah, yeah.
A release cannot be done. In
No.
this.
And remember, in cooperative housing society, okay,
Yes,
there is a one rule. Very few people understand that you can retain
yes,
in a cooperative housing society
yes, sir.
minimum 10% of that society is this one. That means in one society,
Yes, sir.
maximum 10 number of owners
Owners
you
can
can
be
have.
there
You can get that.
for,
Yeah.
for one property, for one
Yeah.
property.
For one property, one flat.
Okay, sir. Okay, sir. Thank you, sir. And also, when you just said, sir, that in a declaration deed, now it is clear. So, if it is a declaration deed, then after the declaration deed, a release deed cannot be made. A gift deed will only need to be done.
Yeah.
Okay, sir. Thank you so much for clarification, sir. Thank you very much.
Dear sir, the declaration deed can be made while the person is alive or after the person is.
No, no, no. That the declaration deed or release deed,
Uh,
it is to be made when the owner dies. Okay? When owner dies, his legatees means his legal owners had to be made. If the owner is alive, then he has to transfer it by gift deed.
and if the owner has expired and he has given it to a one only one legatee, then declaration deed is not possible at all, right?
No, no, no. Listen. If owner is given to only one legatee by what?
Will.
Will. Okay. Now, if he has given to only one legatee by will, let that legatee go to the test. If it is in Mumbai, go to testamentary division of Bombay High Court and get the probate of that will and get it transferred in this one. And remember that in even when probate hearing is there, all all legatees are called there. Remember, all legatees are called. You can very well challenge that will. Okay, when you are called there for giving the probate, you can challenge.
But if there is no challenge,
If there is no challenge, then he will get the probate. Then over. Then with that he will make the declaration deed for himself with the court order of the probate. Okay,
the executor of that will has to make a declaration in favor of the legatee, right?
sir. Executor of the will is dead, no, sir.
Executor of the will.
You see, executor of the will, okay, is yeah, acha, executor of the will, he has got the power what that person has said. Okay. Now here that executor of the will, executor he has got only thankless job of the will. If the executor says, I am not interested in doing any executing work, then that for whom that will says it should go, that person can just do that remaining work and do the testamentary petition for the probate of the will and get it. That's all.
And
Otherwise, if executor is there, it is the thankless job of the executor to get the probate of the will to the testator.
correct, sir. And so the last thing is that the society of the building will have to abide by the probate, or if no probate is there, even though the will is there, they can still manage to get it transferred in Mumbai.
No, 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 no. If a will is there, okay, only that declaration deed and release deed, these are the only the proper document for the society to transfer that property. Okay. Now, if there is no will, then to safeguard the society, then from that person who gets that property, society can ask an indemnity bond on 500 with stamp paper along with an affidavit on another 500 with stamp paper showing that if by chance somebody takes the matter to the court, that society is not responsible. Okay, so with that those things they have to make it and give it to society and society has to transfer.
Hi, sir.
uh,
Uh,
okay.
so there's a case wherein a mother in Mumbai has
Hmm.
died intestate. So there is
uh,
no will to that effect. There is no gift deed, no nothing.
uh,
The facts of the case in two, 3 points are since she's now dead, she has a legally adopted daughter. We have the
hmm,
papers with us, but the mother had mortgaged her flat in Mumbai and
Hmm.
taken a loan from a cooperative bank.
Hmm.
During her lifetime,
Hmm.
the flat went in the symbolic possession of the bank. So as on date,
Hmm.
the bank is has the symbolic possession of the
Hmm.
flat.
Hmm.
Now the point is, this legally adopted girl, she just turned 18. That means she's just a major now, 2 3 months back, and the flat is not in her name. Now the
Hmm.
bank manager is cooperative enough, and he is letting the girl sell the flat. So I wanted to get an idea: will a declaration deed to this effect do? Because this flat was transferred to her mother who died from her
Hmm.
father. माने नाना ने अपनी बेटी को दिया,
Hmm.
और now
Hmm.
her granddaughter is only alive and there is no other legal heir. There is nobody. Her
Hmm.
mother was a divorcee and she
Now, thing
adopted
is
a
that
child.
if she is legally adopted, okay,
Mhm.
through the court, or adoption is done, adoption deed, okay, on 500 rupees stamp paper with the sub register of insurance, it is possible to do the adoption deed. If the by court order or by adoption deed, if that adoption has taken place, then she can get it on her name, declaration deed, and when the declaration deed is made and it is transferred, the whole flat is transferred on her name, and whatever that mother has taken the loan
Mhm.
from that bank, if she is not able to pay off, in that case,
Mhm.
then she can sell that flat and pay
Mhm.
off that loan to the bank and get that remaining money for her own use.
Perfect. So, thank you very much. This cleared my doubt to a very good extent. One subsequent question to this being, if at all the bank is also ready and they are willing to make an MOU and an NOC, they are willing to give an MOU and an NOC to the girl,
Mm.
and
See,
pursuant to which she can sell the flat. So, is that again a valid way to go about it? Because then there should
no,
be.
no, I'm telling you, no, madam, that if the legal papers are existing, that
Mhm.
is, of her adoption, that is,
Right.
that a sub register of insurances adopted 500 rupees deed, or a court order for
Mhm.
adoption, then she is her legal daughter, as if it is she is her daughter from her blood. Okay, and she has got the every right now to do the declaration deed. And
Mhm.
fortunately, that bank is ready
Right.
to
Right.
allow her to declaration deed. And after doing the declaration deed, she will become owner of that flat. And once she becomes owner of the flat, then she can ask bank how much loan exists by her mother,
Mhm.
adoptive mother, and if she is not ready to repay that loan, then she can sell that flat and pay the bank whatever that loan and keep that amount, remaining amount, with her.
With her.
So simple.
Thank you very much. I mean, that saves a lot of litigation trouble and the money
Yeah.
that goes. Thank you very
Yeah.
much.
So, sir, there is a divorcee single woman,
Ah,
and all her self acquired property, and now she's dead. So, she leaves behind her parents, a brother, and not biological sister. So, how will her property devolve?
that court will decide now, because the thing is that the proper lineage is not existing. Proper lineage in the sense that spouse, just now I explained, that is children, grandchildren. Okay, that whoever wants to claim on her part, that court, they have to make a testamentary petition in the proper court. If it is in Mumbai, then testamentary division of Bombay High Court, and if it is elsewhere, in the district court. Okay, and if it is in Chennai or Calcutta, it is again in High Court in testamentary division, and then that court will decide to whom,
In this case, sir, will
how
the
much to be given.
okay, but will the non biological sister get her share?
No, no, non-biological sister means it must be adopted sister. Followed. So sometimes we call mana or sister. She is not coming under biological this one. Followed, no. So so
Okay.
so mana or sister, some people say. So she is not coming under this one. Legally, she should be your sister. That is adopted sister.
But sir, in this case, even if there are divorce papers, she's a divorcee. So now
Hmm.
will it not will the society not transfer it directly to the parents and brothers who are the legal heirs?
No, 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 not at all, not at all, not possible.
Okay.
Yeah, she has to get the order from the this one, and with proper documents, the divorce decree and her marriage certificate of with that divorce husband, and her parents' declaration stating that she is without any children, and other. And court will also ask them to put the give a publicity in the newspaper. So it is possible.
Sir, what is the process of making a gift deed?
See, gift deed has to be made by the person who got that property with his own money, or who it is gifted to him by somebody. Let us say I am having a flat. It is bought with my own money. Then I can do the gift deed. Let us say I am having a flat which was gifted to by my father. I am not having it, but gifted by gift deed. It is gifted to my father by my father to me. Then also I am full owner of it. I can do the gift deed. And sometimes it becomes a jointly owned property. Let us say husband and wife. Okay, people most of the time they forget that in husband and wife owned property, that I had a problem in Money Life Foundation, that at Churchgate there was one flat which was bought by husband 100%, and they wanted to give the gift to one of the child. Then both of them came to me and asked, see, we are the two owners, and it was bought by my husband, but jointly with me, wife. Then what way we can do the gift? I told him that it is fully bought by husband's money, but nothing is stated in the deed by you. So that means that the sale deed of that flat is silent. Who has given the money? Okay. And now that both of you are equal partners to that flat, and therefore that if you at all you want to make the gift deed, together you make the gift deed, or one of you make the 50-50 gift to whom you wanted to gift. So this way it becomes.
Okay. And sir, when a society receives a gift deed from a donee, so then can it legally transfer the flat or some court intervention is needed?
See that when society receives a gift deed, and that donor has to make an application to the society to make him the member. And remember that if the gift deed is there, then that society's premium 25,000 is not to be collected, because gift deed exempts that premium.
Sir, there's a case wherein the society has received an application from a family of 8 children and one mother for transfer of property to his name. The original father was the original owner of the property. He expired intestate, and the mother was added as a member to the society by a general affidavit of 500 rupees by all the children. But wherein they stated that the children have rescinded their rights to the mother. Now the mother has gifted the property to one of the child, and the other children are saying that we have the share in that property. So what is the society bound to do? Transfer 100% to the one child who has been gifted, or just the one
No.
share of the mother to the child?
What did she did earlier? I want to know.
No, only a general stamp paper of 500 rupees was given to the society, wherein the children state that the mother can be added as a member. And
No, on 500 rupees, what's
The affidavit on affidavit.
affidavit?
Yeah.
Yes,
Acha,
sir.
then that document is meaningless. Now coming to second point, that mother has done a gift deed to one son. Okay. So whatever that gift deed is done, on which 1% of the value of the flat, that stamp duty has to be paid, and it is to be registered with sub-register of
Yeah,
assurances.
it's a registered deed. The gift is registered, but it is silent as to how much the mother has gifted. 100% or one means can the mother gift 100% of the flat, considering she is not the owner?
Who was
If
the
you say
owner? 1 minute. Who was the owner?
the father was the owner, he died
Acha.
intestate.
Acha. Father was the owner.
He died intestate.
Then how mother came into picture?
The children and the mother gave a affidavit on a 500 rupees stamp paper.
No. 1 minute. Now that is absolutely useless document.
Yeah.
Because that gift deed has no legal validity. You ask that mother to make a testament. This is in Mumbai, I believe. So
Yeah.
ask that mother to go to a testamentary division in Bombay High Court. And fortunately, in Bombay High Court, in testamentary division, I have got one court person, one court employee, one Mr. Jia. You just remember Jia. Go
Mhm.
ask her to meet Mr. Jia in Bombay High
Mhm.
Court in testamentary division.
Mhm.
In the extension building near Mumbai and Goa Advocates Association. So
Mhm.
their testamentary division is there. In the
Mhm.
testamentary division, you ask her to go and meet Mr. Jia. Jia
Mhm.
will guide her to properly do what she want to do. But
Mhm.
surely, whatever that after the death of father they have done, it is all
Mhm.
wrong. It is
Mhm.
all wrong. In my opinion, that 500 rupees stamp paper, it must have done without registering also with the sub register of insurances. In my opinion.
Yeah, it is not registered. It's notarized.
Then all notarized documents are foolish thing. They are having no value. Followed? No? Huh?
So the subsequent gift deed of 100% of share by the mother
No,
to the
no, no.
one child is
See, if she is making the gift deed, then she should have 100% right in her name. Without
yes.
having the right in her name, she had done the gift
Uh,
and everything is wrong.
okay.
Okay, so gift deed you can challenge it in the court and it will be cancelled and ask her to make a testamentary petition and get it in the name of one or all, whatever the way the children want.
Okay.
Okay, yeah.
No, what I am speaking is from the society's point of view. The society has
No,
received
no,
a
no,
document
no.
for transfer.
Society,
What is the society supposed to do?
you say that we are not this the first thing whatever they have done is wrong. Okay, on 500 rupees stamp paper wrong, and because of that, even if that time society is accepted it, still then you say now it is wrong. Okay, even if society is accepted also wrong, you say, and then you say that her gift deed is meaningless because without she becoming the owner of the flat, she has done gift deed, and therefore that whole thing should be done by making a testamentary petition in Bombay High Court. And when that Bombay High Court testamentary petition is done, that everything will be clear. Okay.
Thanks a lot, sir.
Good evening, sir. I just wanted clarification on the declaration deed. Where do we register this declaration deed? Any court requirements are there, or it's at the sub-registrar's office?
Now here it is to be
Under
registered
which act
with
does it come?
sub-register of assurances. Sub-register of assurance means when you are selling the flat, where you register your sale deed, that office is called sub-register of assurances office. So you will have to go there and register it.
So there was little clarification that section 57 of one Indian Succession Act, which says that in case of Hindu, Buddhist, Jain, Sikhs, will made after 1997 within territories sub-jurisdiction of Bengal, Madras, probate is a must if there is a will. So then, where does this declaration deed, under which act does this come?
See, here I am not going into the dirty laws, okay, what you quoted. Whatever the plain law is available, that only I am just using it. And the whatever the legal knowledge I am giving, nobody can challenge it. Okay, unchallengeable legal plain knowledge, I am using it.
No, actually, sir, in case of intestate succession, the society, we can go to the society, use these documents, right? What the participant is wanting to ask is in what cases a probate is needed. So if a will, if
See, see,
the, ha,
probate is needed for
ha.
the will. Okay. And if the will is not there, then probate is not possible. And if that will is not there, then you make a testamentary petition and you get the succession certificate.
Sir, I asked this question because many of the lawyers, other lawyers have said that uh, release deed or something, they are not giving a clear title certificate on that. That's why I just wanted to know this declaration deed comes under which act. If you could just highlight, I'll read up on that.
Transfer of property. So Transfer of Property Act, right?
See, whatever that declaration deed and release deed, if you ask, go and ask with the advocates, okay, they will say that you do and one testamentary petition, spend 2 lakhs rupees, and after uh, till you get the whatever that reply, I mean from the court, they will not say anything, and fully they will make these deeds, whatever I have quoted, declaration deed or release deed themselves, huh? Without saying that, and they will get you all this one. अरे वो मैंने इतना किया, यो किया, 3 लाख रुपए दो, बस खत्म.
Yes, yes. No, sir, the participant, sir is asking you, आपको पूछ रहे हैं कि कौन से law में आता है, because he wants to do a deep study on that. So declaration deed, it's under the Transfer of Property Act, right? The
Transfer
provision.
of Property Act. Yeah. You
Yes,
just
yes,
went.
yes. So it's a Transfer of Property Act.
Thank you.
Sir, I wanted to ask you,
Yeah.
you mentioned that you can make a declaration deed and only when the property has been bought with your own money. What happens if the flat is gifted to me?
I told you, no, sir. Just now I made it clear. If
Yes.
the flat is gifted or
Yes.
bought with your own money, then it is
Right.
yours.
Okay. Registered deed, yes.
Just now only I made it clear about
Right.
15 minutes back.
Right. All right. Thank you.
Hello, sir.
Yeah.
So if there is a father who has died interstate and mother is there, and there are one son and married daughter. So no one wants to contest, and they want to give it in the mother's name. So as
Mothers?
you suggested, so they want to they don't have any issues, so they want to give it to the mother. The property is in Mumbai. So as you said, then declaration deed should be done by all three, and then release deed by the
listen. Whether it is gift deed or declaration deed.
a
Okay.
declaration deed. Yeah, okay.
Whether it is gift deed or declaration deed, all legatees will be making that. Sorry, not gift deed. Release deed or declaration deed. Okay. If
Okay,
somebody
sir.
says I don't want, that means I will not do release deed. Wrong. That releaser is also part of that release deed. Okay.
Okay, sir.
Ah,
Fine. Yes.
yeah.
Yeah. Thank you, sir.
So there's one question on the chat box. What happens if one of the legatees is staying in a foreign country and is not able to come to India? So how can we go ahead with the process?
Yeah, this question at Money Life Foundation, I have come across some at least not less than 10 times. One of the person is in foreign country, or one of the person, the property is in Mumbai. One person is very old, and that person, that old person is father staying at Kerala, can't come, and one of their son staying in America also can't come. So in which case the other two sons staying in Mumbai, what they have to do when the flat was in mother's name who expired. Okay, in that case, that whatever that you want to make a release deed or declaration deed, whatever that you want to make it, okay, that you can do it by having a, a registered power of attorney. That one who is staying here in Kerala, you can make that registered power of attorney with that sub register at Kerala and send it to the person in Mumbai. And one who is in America, he can do it with the Indian embassy in America, and he can send it to the person who is in Bombay, and in Mumbai he can take that by post. He can send it. He can go to that American embassy in Mumbai, and there he can sign, and then that that power of attorney he can give it to collector of stamps to put the stamp duty 500 rupees on it, and then register it and use it as a on his behalf. In which case, that person, the one who has put the signature as a power of attorney, who is making that person in Mumbai, one of his brother or some sister, will put his signature on his behalf in that document. So it is little cumbersome, but you'll have to do it. Can't help.
Okay. And so one more question in the
Yeah,
chat box. Does a widow daughter-in-law who has remarried have any share in the father-in-law's property?
See, if she is remarried, then the ex father-in-law's property or the late husband's property, her right ceases.
Okay, sir. And what happens to her children from her previous marriage with her
Ah,
deceased husband?
that previous marriage children, they are keeping the property, right in the property. And at this moment, I would like to tell you one small thing which is of help to you. A person, a Hindu person, okay, can marry only once. After his marriage with a lady, if he stays with another lady by keeping the when the wife is alive, then that lady is just having no right on his property. But because of his intimacy with that lady, a child is born from him. In that case, child gets same rights as if his legitimate child has got. But that wife, that keep, will not have any right on his this one. So this is the case.
Okay, sir.
Hello, good evening.
Yeah, good evening.
Yeah, I have two questions.
Yeah, yeah.
Yeah, first, in my society, so there's this issue that the name of the property is on the grandmother's name. That girl's mother and father have died. The property is in her grandmother's name, and she was made as the nominee in the society nomination. She was made as the nominee by her uncle and her aunts. Okay, and the grandmother was present. After a few years, the grandmother got bedridden, and the then secretary or the treasurer, without the grandmother's consent, the uncle and aunt changed the nomination to the aunt's name, to the Atya's name. So now the girl is staying there. Her parents have died, the uncle has also died. The aunts are claiming over the property, and the girl resides there. She pays the bills. So, what can be done in this case, and how can the girl get her rights to the property? Because then she has nowhere to go except for that house. And the aunts are married. All aunts are married, and they have their own houses.
That girl was staying in that
Since
property
childhood.
for how long? How long?
Since childhood she's staying there.
Whose daughter is this?
She is the grandchild.
Grandchild.
Yeah. So the property is in the name of Mrs. X.
The Mrs. X grandchild.
Yeah, Mrs. X ex grandchild. She's an unmarried daughter-in-law. She's an unmarried grandchild.
Okay. Okay. Now, what is the problem with her?
So basically, she was made as the nomination in the society books by the grandmother herself when she was alive. But then eventually the grandmother got bedridden. So the uncle, so her uncle and her aunts, they changed the nomination from her name to their name, to the aunt's name. And now the grandmother has died, the uncle has died, the aunts are claiming over the property. So how can she claim her right back to that property?
See, nominees cannot claim any right on the property. Okay.
Okay.
Nominees cannot claim right on the properties. Absolutely no right. They have to claim the right by testamentary petition in, if it is in Mumbai, testamentary division in Bombay High Court. Okay. Now she has got one line that the original owner's granddaughter. You say granddaughter, that means whose daughter it is? That original owner's son's daughter,
Yeah,
or
son's daughter. Son's daughter.
son's daughter. So then that she has to prove in the testamentary division. Okay. That
The grandmother died without a will.
no, it's okay. It's okay. Her mother is existing. Son,
No,
her
her
father
parents.
existing.
No, both died in her childhood.
Okay. Then her grandmother was the owner. Okay. Now her father, who was grandmother's son. Okay.
Correct.
And her birth certificate with all these documents. Okay. She can make a testamentary petition in Bombay High Court to claim the property right on it, and then you go to that GIA in Bombay High Court in testamentary division. He will write directly. He will guide her properly. Okay. So she can walk, no? That grandchild can walk, no? Properly. She is in a proper manner, no?
Yeah. She's in her 30s. She can walk, but her aunts want a part of the property, and the aunts are married.
Not at all. Not at all. They will never get property. You are fully explained me with your explanation that grandmother was the owner, then her son and son's daughter. This is the lineage, and which she can easily prove in that testamentary petition, so that
Sir, but
others
the
will be
grandmother,
simply removed.
sir, but the
Okay.
grandmother has other children also.
हाँ,
सर, जो ग्रैंडमदर है उनके दूसरे और बच्चे हैं.
और बच्चे हैं तो उनको मिलेगा, किंतु ये जो अंकल और आंट है ना, उनको नहीं मिलेगा.
पर अंकल जो बुआ है वो ग्रैंडमदर की तो डॉटर्स है ना, वो ही तो क्लेम कर रही है.
वो मैडम, वो ग्रैंड मदर का कितने बच्चे जो है ना,
हाँ,
वो जो क्लेम करने वाले उसके बच्चे हैं तो क्लेम कर सकते हैं,
they can remove
उनको
her right.
उनको फुल राइट नहीं मिलेगा.
हेलो.
हाँ, बोलिए.
हाँ सर जी. Sir, I have a question. A father expired intestate, leaving behind three legal heirs. He has a flat in Mumbai. Now these legal heirs want to sell this flat to third person. Do they need a succession certificate? They are Muslim.
They are Muslims.
Yeah.
And वो फ्लैट किसका नाम पर है?
बाप के नाम पे है.
माँ मर गई.
माँ मर गई सर.
अच्छा. और
3 बच्चे हैं.
और ये 3 लड़का क्या है?
ये तीनों लड़के बेचना चाहते हैं सर.
और
जॉइंटली.
और लड़की नहीं ना?
एक लड़की भी है साथ में.
हाँ.
हाँ.
अच्छा, तो उनको इजीली करना है. ओके.
हाँ,
तो चारों बच्चों ने मिलके वो अपना रिलीज डीड कर सकते हैं. उनका नाम पर कर सकते हैं या किसी एक का नाम पर कर सकते हैं और फ्लैट सेल कर सकते हैं.
सक्सेशन सर्टिफिकेट का जरूरत नहीं है ना सर?
जरूर नहीं है. सक्सेशन सर्टिफिकेट जरूर नहीं है.
अच्छा,
रिलीज
इस
डीड
तरह
करो और सेल करो.
अच्छा.
और चारों बच्चों का जरूरी है रिलीज डीड में.
अच्छा सर, ये नॉमिने इसमें सोसाइटी में मेंबर बनने के लिए तीनों अगर ज्वाइंटली बनना चाहते हैं तो उसमें भी सक्सेशन का सर्टिफिकेट का जरूरत नहीं है. मेरली डिक्लेरेशन दे दें अगर तो हो जाएगा.
हाँ. नहीं, ये इनका डिक्लेरेशन नहीं चलेगा क्योंकि 4 बच्चे हैं ना.
जी.
हाँ.
चारों मिलके अगर
तो
दें.
चारों बच्चों ने मिलके डॉक्यूमेंट करना पड़ेगा. तो डिक्लेरेशन डीड वो चारों ने किया तो ठीक है. और
हाँ,
अगर रिलीज डीड करना है 3 बच्चों के लिए तो वो
अच्छा.
लड़की उसमें रहेगी रिलीज डीड बनाने के लिए.
अच्छा, रिलीज डीड को स्टैम्प ड्यूटी रजिस्ट्रेशन करना जरूरी होगा.
देखिए,
या
वो रिलीज डीड हो या डिक्लेरेशन डीड हो, 500 रुपए का स्टैम्प पेपर होता है और रजिस्ट्रेशन फी 1000 रुपया.
अच्छा, इवन पावर ऑफ अटॉर्नी अगर देते हैं तो भी स्टैम्प ड्यूटी 500 रुपए पे हो सकता है.
किंतु इधर पावर ऑफ अटॉर्नी डॉक्यूमेंट नहीं है.
ये पावर ऑफ अटॉर्नी ट्रांसफर ओनली.
पावर ऑफ अटॉर्नी जो है ना, तुम कुछ काम के लिए आ नहीं सकता है ना. तभी वो पावर ऑफ अटॉर्नी डॉक्यूमेंट बनाते हैं. समझो, मुझे एक प्रॉपर्टी लेने का है, मैं रजिस्ट्रार के पास जा नहीं सकता है.
जी सर.
तो मैं 500 रुपए का स्टैम्प पेपर पर पावर ऑफ अटॉर्नी लेता हूँ और बिल्डर को बोलता हूँ तुम साइन करो मेरे तरफ से और ले लो और मुझे दे दो. बस ये पावर ऑफ अटॉर्नी बोलते हैं.
नोटराइज भी चलेगा सर?
नोटराइज नहीं, सब रजिस्ट्रार के पास रजिस्ट्रेशन करना पड़ता है. 1000 रुपया देना पड़ता है. नोटराइज कौन सा भी डॉक्यूमेंट चलेगा नहीं. नोटराइज डॉक्यूमेंट के लिए 0 वैल्यू है.
ओके सर. ओके, थैंक यू सर. थैंक यू वेरी मच.
Hello, sir. Good evening. Sir, if the father, being the sole owner of a flat in Mumbai, died intestate, and thereafter the mother also died intestate, now there are 5 siblings, 5 children siblings. So, what procedure is required to devolve a flat from father to all the siblings in sub-registrar authority records?
अरे, ये डिक्लेरेशन डीड करने का. 500 रुपए का स्टैम्प पेपर पर डिक्लेरेशन डीड करो, सब रजिस्ट्रार के पास रजिस्टर करो, हो गया. पांचों लोगों का नाम पर 20% आ जाएगा फ्लैट।
ओके, एंड देन उसके बाद अगर हम एक के नाम पे अगर रिलीज करना है तो वो डिक्लेरेशन में मेंशन करे कि एक बार डिक्लेरेशन डीड डालने के
नहीं
बाद
नहीं,
उसके बाद रिलीज
देखो
डीड करना है?
डिक्लेरेशन डेट रजिस्टर किया ना, हाँ,
यस।
वो तुमको किसी एक का नाम पर करना है तो रिलीज डेट करो। जिसको नहीं
ओके
चाहिए ना, हाँ, वो नहीं चाहिए ना, वो छोड़ देगा।
ओके ओके, तो
रिलीज डेट में
डिक्लेरेशन एंड रिलीज डीड।
वो जो वारसदार जो है,
यस
जिनको
यस,
कुछ भी नहीं चाहिए वो है, तो रिलीज डेट बनता है। और
करेक्ट करेक्ट।
वारसदार जो है, वो पूरा का पूरा वारसदार को अपना कुछ चाहिए तो वो डिक्लेरेशन डीड बनता है। दोनों डीड के
ओके
लिए सभी के सभी वारसदार वो रजिस्ट्रार के पास रजिस्ट्रेशन के लिए होना जरूरी है।
सर, बट रिलीज तभी होगा जब उनके पास राइट या इंटरेस्ट रहेगा, बट एट दिस टाइम राइट और इंटरेस्ट उनके फादर पे था, जो डिवॉल्व होके सब पे आया है।
बाबा रे, वही बताए ना, फादर मर गया, उनको उनके पास आया कैसा हो, कैसा आता है डिक्लेरेशन? कुछ
सर
कुछ डॉक्यूमेंट किया है क्या?
नहीं, कोई डॉक्यूमेंट नहीं किया तो उसके लिए डिक्लेरेशन करना पड़ता है।
डिक्लेरेशन करने का नहीं, उसमें कितना लोगों को चाहिए देखो पहला।
ओके ओके ओके,
हाँ,
अंडरस्टूड।
अगर अगर पूरा लोगों को चाहिए तो डिक्लेरेशन डीड, ये किसी को नहीं चाहिए या दो लोगों को नहीं चाहिए तो रिलीज डीड, दोनों 500 रुपए का स्टैंप पेपर पर।
ओके ओके ओके, सो इसमें लेटर ऑफ एडमिनिस्ट्रेशन का जरूरत नहीं है?
नो नो नहीं, मैं बताया ना, मैं इधर आज का दिन इसलिए बैठा हूँ, वो वो कोर्ट में जाने का बिना कैसा काम करना चाहिए वो बताने के लिए बैठा है सर। वो लेटर ऑफ एडमिनिस्ट्रेशन जो है वो कोर्ट में जाके लेने का पड़ता है। उसका टेस्टिमोनी पिटीशन के लिए 75,000 रुपीज खर्चा आता है। वकील के लिए 50,000 कम से कम देना पड़ता है। 1.25 लाख रुपए खर्चा आता है। 6 महीने से 2 साल टाइम जाता है।
ओके 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 ओके, अंडरस्टूड सर।
Sir, I wanted to ask you,
या
family arrangement and declaration is one and the same thing?
no, no. Family arrangement means, in the family arrangement, in whatever I have stated now,
Yes.
declaration deed and release deed,
Uh,
in which whatever that everybody is getting here,
uh,
equal, okay?
okay, okay,
And it is government, because you are equally sharing, you are equally getting. In release deed you are releasing, means some of them are saying that we don't want, follow it,
right,
no? So
right, I follow.
everything is taking place uh, amicably. So government has given them a gift, that is the only on 500 rupees stamp paper you have to do, and registration fee is 1,000.
So
But when you are making,
declaration, right, sir. So declaration is where people get all equal share, right? Family
everybody
arrangement is,
wants, everybody wants.
right, right, right.
लिगेटिस मीन्स वो वारसदार जितना है ना, वो
हाँ,
जितना वारसदार है पूरा वारसदार को चाहिए। तो
बराबर.
किया तो डिक्लेरेशन डीड।
Okay, understood.
किसी
Family
एक
arrangement is
वारसदार को
different.
किसी एक वारसदार को नहीं चाहिए,
वो रिलीज डेट.
रिलीज डीड।
हाँ, और सर ये रजिस्टर होना जरूरी है या खाली स्टैम्प पेपर
ना
पे
ना ना, रजिस्टर के बिना होता नहीं। वो
होता
सब
नहीं?
रजिस्टर के पास रजिस्टर करना जरूरी है, सभी लोग जाना जरूरी है। उनका वो जो रिलीज जो डीड करने वाले वो लोग प्लस 2 लोग ज्यादा विटनेसेस जाना
हाँ,
जरूरी
right,
है।
sir. So, sir, cooperative society, will they accept the family arrangement instead of a declaration?
देखो फैमिली अरेंजमेंट है ना, ये
जी,
फैमिली अरेंजमेंट में वो अनइक्वल रहता है।
हाँ,
ओके,
बिल्कुल, right, right.
अनइक्वल मीन्स ये समझो, ये आदमी को 25%, ये आदमी को 20%, इसको इतना परसेंट, ऐसा वैसा करके करता है। और
हाँ,
फैमिली अरेंजमेंट में तुमको 6% स्टैम्प ड्यूटी भरना पड़ता है।
अच्छा, हाँ, 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 अंडरस्टूड, अंडरस्टूड, राइट सर.
हम्म,
सर एक और क्वेश्चन है. एक वह पर्सन पास्ट अवे, उसने नॉमिनेशन, उसने विल बनाया था, उसकी 2 डॉटर्स है और उसकी वाइफ है. वो विल उसने सोसाइटी में सबमिट किया, सोसाइटी ने बोला आप प्रोबेट करा लो. अभी वो कहता है कि नहीं मुझे प्रोबेट नहीं कराना है, फैमिली में कोई डिस्प्यूट नहीं है, उनकी वाइफ और 2 बच्चे लोग दे आर ऑल अलाइंड, सो दे वांट टू नाउ मेक अ डिक्लेरेशन. और
डिक्लेरेशन डीड, एंड
हाँ,
डिक्लेरेशन
बट
डीड के लिए वो
हाँ,
विल का कॉपी अटैच करो।
अच्छा, अच्छा, लेकिन वो सोसाइटी बोलती है तुमने विल दिखा दिया तो अभी उसको प्रोबेट करना जरूरी है.
नहीं
वी विल
नहीं,
नॉट
वो
एक्सेप्ट अ
इट
डिक्लेरेशन.
इज अनफॉर्चुनेट, इट इज
हाँ,
अनफॉर्चुनेट, बहुत सोसाइटी को ये मालूम नहीं है, समझा
हाँ,
ना? वो
राइट,
विल के लिए विल 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 को प्रोवाइड करने के बिना आप
हम्म,
नाम पर ट्रांसफर करते ही नहीं, समझा
करेक्ट
ना।
करेक्ट
और विल तुम प्रोबेट भी किया ना,
हाँ
प्रोबेट भी किया ना,
हाँ
तो डिक्लेरेशन डीड करना ही पड़ता है,
करना ही पड़ता है, करेक्ट, बट वो
करना ही पड़ता
सोसाइटी एक्सेप्ट नहीं
है।
करती, वो कहती है तुमने विल दिखा दिया तो अभी
हाँ
आप डिक्लेरेशन नहीं कर सकते हो, अभी आप विल प्रोबेट कराओ, बट ऐसा तो गलत है एक्चुअली।
हाँ, गलत है, क्योंकि वो इधर सभी एडवोकेट वही बोलते हैं, क्योंकि उनको पैसा खाने का रहते हैं।
हाँ सर, बराबर है, थैंक यू सर, थैंक यू।
So I have a question.
Yeah.
Suppose there is an old person or a person who is bedridden, and
हाँ
the person wants to make a will and
हाँ
can't go to the registrar's office. So
हाँ,
is there any provision wherein uh,
what for
what
will,
is it?
even
Sir.
even for selling of the flat also, that provision is existing now. Okay. So what you have to do, you have to get the medical certificate. Okay. Medical
Okay.
certificate from from a from a private hospital, from a government hospital or municipal hospital. Okay. huh? And with that, you have to go to sub registrar. Okay. huh? That sub registrar, you make an application, on his behalf, that his son or any workable person can make that application, and registrar will come to your home. That some 2000 rupees is visiting fee you'll have to give him. Okay. And he will do the registration work. That provision is existing from British time
Okay, sir.
for any document, for any registrable document.
Okay, sir.
That registrar will come either before his time or after his time, not in between time. That means his office is starting from 10 o'clock to 5 o'clock. Okay. So he will come at 10 o'clock to your place, do the work, and go to his office.
Understood, sir.
Or 5 o'clock, before 5 o'clock, he will come to your home and complete that work, but not in between.
Okay, so the witnesses and all, they can be called home and
Everything,
registration process
Yeah,
can
yeah,
be.
yeah, yeah.
Okay, sir.
So two questions over here. First case is wherein father has died. There is a wife and two children who are in foreign country. Can they directly sell to a purchaser or a declaration deed is needed
See, now the flat is on whose name?
in father's name?
Father's name. And mother is alive?
Mother is alive, two children are alive in foreign countries.
Acha, all are in foreign countries.
No, mother is in India.
Mother is in India. So those children in foreign country, they have to give power of attorney to mother.
Okay.
Okay. They have to give power of attorney to the mother. And if they are not interested in coming, they can make the power of attorney in the Indian embassy in their country, and that she can, they can send it to her mother, to their mother here, and mother will go to that country's embassy in India and put the sign in front of embassy of that country, and then give that power of attorney for adjudication with the collector of stamps, and put the stamping and registration, and then use it for selling. It is possible. It is
In
possible.
case the children are ready to come to India, can these three people directly sell to a buyer or a declaration deed?
It is easy.
No, or a declaration deed is needed and then they can sell to a buyer.
No. Look. That flat was belonging to whom?
Father.
Expired. Oh, acha. Then they have to make the declaration deed here.
Okay, first they have to make a declaration deed.
Yeah.
Then only they
Declaration
can
deed.
sell.
And then only sell.
Okay. Second case is wherein father has died and mother has died. These are Christian families. Father has also made a will and mother has also made a will. There are two children and both of them been mentioned in both the wills. So is means as per Succession Act, if the family is a Christian, no succession certificate is required, no probate is required. So can the children directly sell the flat to a buyer, or is a declaration deed again needed?
No. Look. That flat belonging to whom?
The flat was belonging to father. He
Father.
made a will. He made a will.
1 minute. Father. The flat was belonging to father.
Father.
Okay. Huh?
Christian father. The family is
No,
Christian.
whatever it is.
Huh.
And he made a will.
He made a will. Then mother died. Even she made a will.
1 minute. Father's flat transferred to mother.
No.
Then
only will is there. No transfer. Only will is there. No transfer because there is no society. There is no society.
What is that house then? Is a bungalow or?
It's a building. It's a building, but there are only 4 families. So no society.
Acha, only 4 families.
Yeah.
No society.
No society.
Acha. In Mumbai?
In Mumbai.
Acha. Then in that case, this is unfortunate that all 4 families, I don't know how that family are staying. Now, in such a case, how that building is? Hello?
The building was constructed by one person.
No. Is it a single story building or multi-story building?
Three story.
Huh?
3-story.
3-story building.
Yeah.
Now, thing is that 3-story building, that means in each floor somebody is staying, isn't it?
Yes.
Huh?
Yes.
Now, in such a case, okay, there are 2 documents with each flat holders. One document is that registered flats sale deed.
Yeah. Yes.
Are they having that registered?
Yes, registered flat sale deed they have. In the father's name.
Everybody is having in father's name. Everybody is right.
No. There are total 3 flats. 4 flats. Every person, every flat has their own sale deed with them. Of that one flat owner, I am speaking about one specific flat owner. There is no society in that building. One of the flat owners has died. He has 2 children. The mother has also died. It's a Christian family.
No. Here you are confusing. That you first said that 4 flats, no society.
Yeah, no
now
society. There is no society. There is no society.
You are talking about the one flat or all 4 flats on the society?
4 different families, 4 flats, no society.
No. Are you talking about one flat or all the 4 flats?
One flat.
One flat. Okay. So you are talking about, your question is of only one flat among the 4.
Yeah, one flat among the 4.
Okay. Now in such a building, that each of the flat owner, okay, their name should be present on the lands document also.
That is there.
Lands document. There are 2 lands document. Out of 2, one document is very important. That document is called property card. Okay. And property card is maintained by sub-registrar of assurances. And where sub-registrar of assurances of your area, if you don't know, then you go to your collector's office of your district, and there, if it is Mumbai suburban district, that collector is in Bandra. If it is Mumbai city district, collector is in Old Custom House. Okay. And there you can go and ask, tell your address and ask where my sub-register of this property card is maintained by. Property card is maintained by, I have forgotten. Anyway, so
property card will be maintained by the city survey department.
City survey, yes, city survey. Sorry, city survey department.
But the property card is not in the name of any of the families. It is only the name of the original purchaser of the land.
Original purchaser of the land.
And then the purchaser of the land. The purchaser of the land has constructed the
original
flats.
purchaser of the land. Okay. Hello.
Yeah.
It is original purchaser of the land who has built that building. Yes or no?
Yes, he has made the building and he has sold the flats to the 4 families.
Okay. That man is alive.
Yeah, he is alive.
Then ask that man to transfer all these flats owner's name in the what is it?
Property card.
Who is maintaining property card? I am forgotten.
City survey.
City survey office. Okay, ask them to go to city survey office and transfer it. Okay. So that first thing he has to do.
Okay.
Okay. Or once this is done, then that you are come to you are come with the problem of one person owner of the flat who expired.
Yes.
So how many children and wife or what he has got?
Wife has also expired.
Huh.
Both have
Children,
made
how
a
many
will.
children he has got?
Both have made a will in the name of 2 children that they had. They have.
Okay. Now both making will is meaningless because that man was having the flat, not wife. Okay. Let that wife's will be as it is.
Okay.
But with the man's will, okay, they can that his 2 children make declaration deed, and after making the declaration deed, they will become the owner of the flat. But because there is no society and their name is not there on the land, they cannot sell the flat.
Okay.
All flat owners, once these children become the flat owners, then all 4 flat owners together will ask pressurize that landowner
Okay.
to go to city survey office
Okay.
to transfer their name in that land.
Okay.
And when that name is transferred in the property card in their name, all will get undivided equal share of that land with them.
Okay.
Undivided equal share means that they cannot carve the land, not at all.
Okay.
Undivided share. Everybody
Okay.
will be 25% owner.
Okay.
This you have to do because fortunately that landowner is still alive. Otherwise, you'll have to go to court.
Okay. Okay, sir. Thanks a lot, sir.
Sir, as you said that father's property develops upon the legal heirs by way of declaration or by release deed. So basically, this is a transfer, or this is not termed as a transfer, no?
Transfer, legal transfer.
So usual stamp duty is not required in this case.
I told you
Like
no, on
6%.
500 rupees. 500
Only
rupees stamp.
Only 500 rupees. Is
Only
that
500 rupees. Yeah. Government is made that.
Acha.
Without that person whose property it is, dead person
Father's.
property.
Huh.
Dead person property.
Yeah.
Okay. Dead person property, you are sharing amicably. So government has also given you the gift.
Okay. Okay, sir. It is not interviable.
Yeah.
Okay, sir. Thank you, sir. Thank you very much. Acha, sir. If suppose there is a dispute between the legal heirs, and one of them go for the partition, and some partition decree is ordered. So in that case, they have to pay the stamp duties.
I have not heard that legal hair, if they are doing the partition and all, okay, court will call everybody in the court.
Yeah.
Have they gone? Everybody has gone?
Yeah, everybody has gone. Then there will be a decree, partition decree. So on that partition
On
decree,
that partition decree, that full stamp duty one has to pay.
Acha. Yeah. Okay, sir. I got
See,
my
government has made, but this you should not fight. So no fighting, then 500 rupees. Fighting 6%.
Okay. That is a penalty.
Yeah. Fighting 6%. Plus,
Okay,
plus, not only 6%, plus he has paid that petition charges and
Yes.
advocate charges in
Court
fighting
fees
in the
also. Yeah.
testamentary petition.
Yes, sir. Acha, in petition also we need a succession document certificate.
No, see, in partition petition, the court will call all the legatees, okay, who are the legal heirs, okay. Even if a person dies with a will, even in that will, the only one among the some five children name, only one person name is there, then with the wife and 5 children, the court will call and
Okay.
will take the declaration from everybody that I have no objection for it, or I don't believe that will is wrongly made, this one other thing, and then court will give the order.
So basically, the partition court has to decide the shares of the litigant.
Yeah.
They won't require succession certificate in that case.
See, succession certificate, when a person dies without a will, then succession certificate will be given by the court.
Okay. But
When you
when
make
we
a
are
testamentary petition, when you make the case in the court
Hmm.
for getting the property of the person who dies intestate, means without making the will, then that succession certificate is given by the court.
Okay. The court where partition suit is filed will give the succession certificate.
Yeah.
Okay, sir. Okay.
There is a question, sir. Like there is a property in two names. Both are brothers. They are co-owners. So one of the brother is willing to sell his share. So by what way he can just do it? Could you help me on this, sir?
See, it is a property in the sense land or a
Flat.
flat.
A flat, sir.
Flat. Okay. If the flat is jointly owned, okay,
Yeah.
and if one of the joint owner want to sell his share, he has to take NOC of that other owner.
Okay.
Without NOC, he cannot sell his part.
Okay. Sir, he doesn't want to sell the entire flat. He just want to transfer the property like to the single person.
I didn't understand.
Wow. Sir,
See,
yes.
even listen, if two brothers are there, okay,
Yes.
one brother is having some medical problem and he want some 5 lakhs. So what he will do? He says that if I do the mortgage to the bank, then I cannot pay this one. What is that? Interest on it. It will be tremendous. So I want to sell part of my property to somebody so that he can this one. In that case, he has to take the NOC of the joint owner. Okay, and he has to make a proper agreement with that buyer with confirming party at the joint owner. Confirming party with the, because joint owner will also sign that
Yes, sir.
partial sell deed. Okay, and
Yes.
in that buyer has to make all, in the sense he will not come and stay here. He will for that part he will get some rent from that uh, part owner of the flat. Like this, he will make.
But they are not willing to sell, sir. Like
I'm
they
telling
are.
you, no, I'm giving you the answer same. If they are not
Okay.
willing to sell, then for part selling, that this has to make made.
Okay. Okay. And there is another question, sir. Like there is a grandfather. Like he made a will, and just a second, sir. He made a will actually, and my father is the owner of the property. And he mentioned that thing into his will because he paid the money for that property. And now the property belongs to my father, and but it is mentioned in the will and it is divided into the brothers and sisters. So how will this be react on this, sir? Could you help me on that?
No. Look. Your grandfather is alive or died?
Died. He made will. Yes.
Okay. If he makes the will, because your father is given the full money for that flat bought
Yes.
by the grandfather,
Uh-huh.
how after his death that flat goes to others? There is no logic here.
Yes, it is registered on my father's name, sir.
If it is registered on the father's name, then you said that it has gone to somebody else also.
But according to will, like my grandfather paid the overall money for that particular flat.
Okay.
So he just mentioned it into his will, and all the his sons and daughters are getting the property. So, but according to the registrar, he is the rightful owner.
No, I didn't understand your problems. Surely I didn't understand your problem.
Okay.
Sir, I have a question.
Yeah.
Sir, there's a flat in Dombivli, and it's been jointly owned by father and two sons. So the father and one son want to give up their rights to the second son. So should it be gift deed or release deed?
No. Release deed means is always when the owner dies. It is gift deed.
Okay, fine. It is a gift deed by both father and one son.
Yeah.
Okay, sir.
And with
Thank
the
you so
one
much.
only one document you can make it. So that person to whom that the both the donors are the owner of that same flat, no? So
Yes, sir.
therefore, both of them make only one gift deed and do that.
Okay, sir. Fine. Thank you so much.
Hello, good evening, sir.
Good evening.
Suppose if the husband wants to add his wife's name in his property,
Ah,
he is a single owner. If he wants to add wife's name in the property, what
hmm.
are the formalities? Like, does he
Gift
have to
deed.
pay stamp
See,
duty?
yeah. Stamp duty exists. Now stamp duty and stamp duty is 1%. 1% of the market value of the flat. Okay. And I suggest that you should give 50% of his flat to his
Okay.
wife. Of course, if he has got children, he can give some part to the children as well, which I suggest. And the stamp duty exists. The whatever the gift that you are giving, it's that flat that you are gifting. Hmm?
No, it is not a gift. Actually, joint ownership. I'm talking about joint ownership.
No, no. That flat belong to whom?
The husband.
Husband. Okay. Then how come joint ownership comes when the flat is
No,
owned
suppose if
by
he
the
wants
husband?
to add the wife's name or the wife wants to add. Yeah.
Now you have come to the right point.
Yes.
When he wants to add his wife's name, okay, adding has to be done by a gift deed. Okay,
Okay. Okay.
gift deed. Uh, Whatever the part of the gift that you are making, I suggest if the husband and wife want to share, let the gift deed be 50% of the
50%.
flat. Okay,
Okay. Okay.
and whatever the market value of that flat, it's 1%.
1% of the stamp duty.
1% is the stamp duty on that gift deed, and for registration charges is only 200 rupees.
Okay, sir. Okay. Thank you so much. Thank you.
So, sir, we are done with the questions. Can we conclude?
Yeah.
So, sir, thank you so much for
Yes.
sir. आपके जितना पेशन और पैशन आई होप हम सब में आए. Thank you so much for sharing your expertise and all your experiences with us today. Okay, sir. Thank you so
Yes,
much.
thank
Bye,
you.
sir.
Yeah, bye.